Hello everyone, my name is Shivi Rajput and I'm a partner at Stowe Family Law. Welcome to today's webinar on making and defending international relocation cases, practical tips for family lawyers. I'm delighted to be guiding you through this complex but increasingly relevant area of the law. Whether your client is the parent wishing to relocate or the parent being left behind, these cases are often emotionally charged, legally intricate and strategically demanding. Today, we'll be looking at both sides of the fence, how to make or defend an international relocation case from start to finish. Let's start by having a look at the course aims. This webinar is going to cover a comprehensive review of the statutory framework governing relocation decisions in England and Wales. We'll look at some practical insights into international issues, including the Hague Convention, enforcement of orders, and resolving disputes involving international foreign jurisdictions. There will be a review of the essential and recent case law shaping the area of family law, the critical factors in relocation cases such as the child's welfare, the impact on family ties, cultural integration, and the effect of contact on the non-relocating or left behind parent. And we'll conclude with step-by-step guidance on how to make or oppose a relocation application, covering drafting statements, gathering evidence, and presenting a compelling case in court. Applications for the court's permission to remove a child permanently overseas usually arise in one of the following circumstances: where the applicant has remarried or is in a new relationship and the new spouse or partner either lives abroad or has their job or business located abroad, where the applicant has been offered employment abroad, where the applicant wants to return to their native country or to emigrate to a country where their family has settled, or where the applicant wants to emigrate to another country on the basis that that foreign jurisdiction offers a better lifestyle than that of England and Wales. So who can remove a child from the UK and for how long? No one can remove a child from this jurisdiction if that child is subject to a child arrangements order which regulates when or with whom the child is to live without the prior written consent of every other person with parental responsibility or PR, or without prior permission of the court. However, a person who's named in a child arrangements order as the person with whom the child is to live can remove the child for a period of up to 1 month, and that's contained in Section 13 of the Children Act 1989. If a parent has PR but is not named as the person with whom the child is to live in a child arrangements order and removes a child without consent, that would be a wrongful removal. In those circumstances, the left behind parent could bring an application for the summary return of the child under the Hague Convention 1980.